When a cop asks about your gun, one wrong word can turn a legal firearm into a felony. Today, I'll show you the 5 responses that destroy your defense before you reach a courtroom. Learn the exact words that protect you and what never to say. Here's the cleaned up version of your script without timestamps. When a cop asks about any gun, and your legal firearm turns into a felony charge. I'm talking about the exact phrases prosecutors pull from police reports to build cases against law-abiding gun owners who thought they were doing everything right. Today, you're learning the 5 most dangerous responses that obliterate your legal defense before you reach a courtroom. By the end, you'll know the precise words that protect you and the phrases that hand prosecutors everything they need. Last year in Texas, a licensed carrier said just 4 words during a routine stop. Those 4 words cost him his carry permit, over $8,000 in legal fees, and 2 years fighting charges. He believed he was being cooperative. He was completely wrong. Smash that subscribe button because this information could save you from financial ruin and protect your Second Amendment rights. 1. Yes, I have a gun. Dangerous response number 1. Yes, I have a gun. This sounds cooperative and honest. Here's what prosecutors do with that statement. When an officer asks about any weapons, your instinct is to answer directly. The problem, that phrase legally establishes possession without showing it's lawful. It doesn't mention your license, doesn't clarify location, and doesn't establish legal justification. Under the legal doctrine of admission against interest, those words become prosecution evidence. You've confirmed the gun is yours, but given 0 information about legal authority to carry it. In Texas 2019, a concealed carry holder responded, "Yes, I have one," when asked about weapons. The officer immediately cited him for violating Texas Penal Code 41122-2005-205, failure to provide proper notification. Texas law requires specific notification language, not a simple yes. Result, court appearance, over $8,000 in legal fees, and 6-month license suspension. His attorney confirmed proper wording would have prevented the entire prosecution. Here's what protects you in duty to inform states. Officer, I'm notifying you that I'm a licensed concealed carrier. Full stop. This establishes your legal status and fulfills notification. No elaboration, no extras. But most gun owners think volunteering more information reduces tension. The second response proves why that instinct destroys your defense. Dangerous response number 2. It's in my glove box. It's in my glove box, under my seat, or in the center console. Here's what prosecutors do with location details. You're stopped for a broken taillight. Officer asks about weapons, and you want to be transparent, so you tell them exactly where it's stored. You just established knowing possession and immediate control, the 2 critical elements prosecutors need for illegal carry charges. If that location violates any ordinance or storage requirement you weren't aware of, you handed them their entire case. In Florida 2022, a driver told an officer his handgun was in the center console. The officer found it loaded without a secured container. The driver had a valid permit, but Florida Statute 790.025 mandates specific storage requirements. His voluntary description became the prosecutor's evidence, proving immediate access without compliance. The charge, improper concealed carry. The damage, over $6,500 and 19 months of court proceedings. His attorney stated the case would likely have been dismissed if he declined to specify location. Your protective response after notification when asked where it is? I'd prefer to discuss specific details with my attorney present. Comply with all safety instructions, but don't volunteer location information. Dangerous response number 3, I have my permit. Here's what prosecutors do when they verify. The issue isn't declaring your permit. The issue is what happens when the officer checks. Maybe your permit expired and you forgot to renew. Maybe your new state doesn't honor it. Maybe there's an administrative suspension you don't know about. Now you've provided false information to law enforcement, a separate criminal offense in 43 states. In Virginia 2023, A permit holder told an officer, "I have my concealed carry permit," during a speeding stop. The officer discovered it was suspended 4 months earlier due to an unpaid citation. The driver never received suspension notice after relocating. He had zero knowledge his permit was invalid. Charges: carrying without a valid permit under Virginia Code 18.2308, plus false information to law enforcement. Total cost: over $9,000 in defense fees, 14 months of court appearances, and a permanent criminal conviction appearing on every background check. The wording that protects you. Officer, I'm a licensed carrier, and I'd like to verify my current permit status through counsel before continuing. If valid, your attorney confirms it immediately. If there's any issue, your attorney resolves it before you've made statements prosecutors can quote. Dangerous response number 4. It's for protection. Here's what prosecutors do with this explanation. The officer asks why you're carrying. You want to sound responsible, so you explain it's for protection. You just established deliberate intent to have that weapon accessible for defensive use. If your carry situation is illegal for any reason, wrong zone, license problem, different jurisdiction, the prosecutor has your recorded statement proving you intended it accessible for use, which can upgrade charges from technical violations to intentional weapons offenses with harsher penalties. In California 2023, a CCW holder was found armed in a posted gun-free zone. When asked why he was carrying, he said, "For protection, there's crime around here, and I have a legal permit." The DA used that statement to argue he deliberately violated posted restrictions, valuing personal protection over legal compliance. What could have been a misdemeanor became a felony charge under California Penal Code 26-230. The nightmare: over $12,000 and 21 months before resolution. When asked why you're armed, your only safe response: "I wish to speak with counsel." Don't rationalize, explain, or justify. Your reasons are between you and your attorney, not roadside statements. Dangerous response number 5. I wasn't going to use it. Here's what prosecutors do with panic statements. The officer finds your firearm and you want to de-escalate. So you say, "I wasn't planning to use it," or "I forgot it was there." You just confess to knowing possession while wrecking any Fourth Amendment challenge about the search itself. When you say, "I wasn't going to use it," you verified you knew the firearm was present. That eliminates arguments it was planted or you were unaware. When you claim, "I forgot it was there," you're admitting negligence. In states with storage statutes, negligence is a distinct criminal violation. When you insist, "I never touched it," you're inviting forensics. When your prints appear on it, you've made a provably false statement. That's another charge. In Georgia 2023, a driver was stopped with a visible firearm on the rear seat. When the officer spotted it, the owner blurted, "I'm not going to use that. I forgot it was back there after the range yesterday." The officer cited improper storage. The prosecutor used his admission to prove knowing possession with failure to secure per Georgia Code 16-11-26. What should have been a $150 citation became a misdemeanor with $1,500 fine, mandatory safety course, and 18 months probation. If an officer locates your firearm, say nothing about it. Your only statement: "I'm exercising my right to remain silent and I want counsel present." Nothing you volunteer improves your situation. Everything builds the case against you. Your quick legal protection checklist. Let's recap the 5 responses that obliterate your defense when police ask about your gun. 1. Yes, I have a gun. Establishes possession without legal justification. 2. It's in my glove box. Proves knowing control. Prosecutors weaponize. 3. I have my permit. Exposes you to false statement charges if any issue exists. 4. It's for protection. Gives prosecutors intent evidence to upgrade charges. 5. I wasn't going to use it. Admits knowledge and destroys every defense. Any single response can cost you thousands in fees, your license, and your freedom. When police ask about firearms, I'm exercising my right to remain silent, and I want counsel. Conclusion. When an officer asks about any gun, give notification only where legally required. Then invoke your right to silence. Now, I want to hear from you. Have you been stopped and asked about weapons? What did you say, and how did the officer respond? Drop your experience in comments because your story could help thousands of other gun owners. If this video gave you legal knowledge that could save you from prosecution, hit that like button and subscribe. We're building a community of informed gun owners who know their rights. Stay legally protected, and remember that silence is your strongest defense until your attorney stands beside you. Always give only legally required notification and stay silent until your attorney is present. Anything you volunteer can be used against you in court. Stay protected, know your rights, and let your lawyer speak for you.